All right, I have two motions here that do have like answers from the judge, and that's the issue with this. Okay, this one, and then this other one. The judge is writing his orders like that. He's doing the same thing he did last time with his orders, and that he's just saying come to the hearing, come to the hearing. And when I saw that before, I assumed that the prosecutor wasn't gonna write any answer, and he did. The prosecutor brought his answer to the hearing, so that threw me off guard. So, well, now I know this time. All right, here we go. Objection to motion for discovery by the city of Natchitoches as it is time barred. Now comes in the court Travis, who responds to state's motion for discovery and states as follows: is in accordance to Criminal Code Procedure Article 521A, a pretrial motion shall be made within 15 days after arraignment. As of the date of the motion for discovery made by the city, the defendant has yet to be arraigned. So you can see this as a game. Defendant has a right to legal due process and an adequate legal counsel to instruct a response in a timely due process. Wherefore, the defendant respectfully requests this court sustain the defendant's objection as a matter of statutory procedural rule and deny the city of Natchitoches motion for discovery. See, I didn't argue that because I just wasn't aware on February 15th. And then I wrote the order here, unsigned, and this is what threw me off, was the judge wrote his own order, pretty much saying come to the hearing on 7th of March. That doesn't mean that's the answer. That's just he's just saying come to the hearing. Prosecutor still will have an answer. That threw me off. I did not know what I did not I was really surprised to see what prosecutor wrote. Let's see. Answer to City of Natchitoches motion to quash, defendant's motion to quash, as it relates to improper admission of facts not in evidence and request for reconsideration. This is a reconsideration. Now coming to court, Travis Hines pro se responds to City of Natchitoches motion to quash, defendant's motion to quash, and states as follows: on February 4, 2022, defendants made a timely motion and rule to show cause, which the court ordered production by February 15th. The motion made by the defendant is a matter of legal procedure. It is a pre-arraignment motion. It does not rely on facts to be established at a trial and in proper accordance to the Code of Criminal Procedure, Article 215.1, and State Supreme Court case law, White v. Morris. The defendant made a timely motion to quash in accordance with Code of Criminal Procedure, Article 535A5, where the city failed to show cause supporting probable cause of the defendant's arrest by establishing the reasonable articulable suspicion of a crime that permitted officers the legal authority to detain or arrest, which is a procedural issue. A copy and pasted statute does not suffice or show cause to the specific matter at bar. The city of Natchitoches failed to show how the court had jurisdiction, CCRP 535A5, over an individual who, based on the testimony of police officers in their own reports, had not committed a crime or that warrants a secondary charge of failure to identify. The state alleging that a crime took place which gave officers of the Natchitoches Police Department reasonable suspicion that crime had either taken place, was taking place, or was about to take place. That placed Mr. Hines under detainment. Under Terry v. Ohio, an officer must be able to articulate based upon specific facts what crime had occurred, was in the commission of occurring, or was about to occur. The officer must have developed these articulable facts prior to being able to detain a person. He could not base his decision on speculation or a hunch. Such facts would have been supported by affidavit and would have been the primary charge, and the defendant would have then been charged with both a primary charge that the officers developed reasonable articulable suspicion for where they then had authority under the law to detain the defendant. Because they did not have a primary charge as shown in the record and only have the secondary charge of resisting an officer by failing to provide identification after one is detained or arrested, they fail to meet the elements of the only crime charged. If an actual crime had occurred, the complainant, Mr. Rosalind Parker, would have been the reporting party in the report and not the officer. The matter herein states is not a question based upon evidence in the record by witnesses, but a procedural question to provide the legal basis which supports the charge as made in the arrest affidavit supporting probable cause signed by this court. The elements of the accused crime, officer's reasonable articulable suspicion which established the element to affect the arrest at the time of arrest as defined in Louisiana Code Criminal Procedure 215.1, how the defendant was in custody at the time of arrest, and for what crime the defendant was in custody for prior to the officer's allegations that the defendant failed to identify as required, as failure to identify as a secondary crime to first being detained or arrested for a primary criminal act. The city of Natchitoches incorrectly holds that this court does not have the authority to quash the bill of information as a matter legal procedure and law prior to arraignment or trial when based upon the facts presented by the arresting officers through their own police reports, arresting affidavits, warrant affidavit, and supporting documents fail to show that any crime were committed which placed the defendant into a custodial detention or arrest prior to arresting the defendant for a secondary charge. The city of Natchitoches correctly proffers to this court that that Code of Criminal Procedure Article 215.1 is the governing code, and the defendant's motion to quash and is subject to pre-arraignment and pre-trial motions. Okay. However, the city of Natchitoches failed or neglected to direct the court's attention to the governing case law in this matter, White v. Morris. Also see Norrell v. City of Monroe, which has the exact same elements to the case at bar at the time of arrest and clearly mandates that a case which does not meet the requirements set forth in Louisiana Code of Criminal Procedure Article 215.1 must not proceed to arraignment, let alone trial. This court and city district attorney are subject to the Louisiana State Supreme Court in its rulings. Defendant herein reaffirms the law as originally presented in defendant's motion. The statute at which Mr. Hines was charged requires that the defendant be first legally detained or arrested for a subsequent prior violation, or at a minimum a reasonable suspicion of a crime. An individual cannot be detained by a mere presence of the police where there has been no reasonable articulable suspicion of criminal activity supported by fact. Terry v. Ohio. As the Bill of Information charges a crime to which the elements of the crime had not been met, the Bill of Information fails to charge an offense that is punishable under a valid statute. A Bill of Information which fails on its face should be immediately quashed. The court does not have jurisdiction to sentence a defendant who has not committed a violation of a statute, and to do so is a fundamental miscarriage of justice which would allow federal habeas review. And some references. Once the defendant had actually been arrested, he complied with the law and identified himself immediately. At no time did the defendant give false information to law enforcement officers, and law enforcement does not claim the defendant ever gave false or misleading identifying information to them. Law enforcement officer Davis details in his report that no crime had occurred prior to or after arresting the defendant. The defendant had not been detained and was engaged with law enforcement in a consensual contact. The interaction between Defendant Hines and law enforcement officers was not Terry stop, as no laws had been violated, and there were no reports to law enforcement of any law violations, and responding officers had not witnessed anything the defendant had done prior to their consensual contact which would have given them reasonable suspicion that a criminal activity was occurring. Responding officers had not developed any reasonable suspicion that a law violation had occurred, and had not conducted any investigatory measures to determine if any law violations had in fact occurred. There was no basis to the arrest. The defendant was never detained. No reasonable suspicion of a crime had been established, and the defendant was arrested without probable cause. Wherefore, the defendant respectfully requests that this honorable court, through its judicial duty, take judicial notice herein of the preceding information for consideration prior to allowing a defective case to proceed. And did he have a signature? Let's just... Okay, here... it was judicial notice, and of course... the city judge Owsley said, just come on in March 7th, and we'll give you another nice fair hearing.